You are welcome to Company and Partnership Law class. This is the last session on Unit 6. Session 6 of Unit 6, which deals with winding up order. Session objectives. By the end of this session, you should be able to identify the relevance of just and equitable principle in making a winding up order. Identify the source of animosity between company directors and members. Remember, winding up order is the process of taking steps to ensure that a functional corporate body or going concern company or body ceases to be going concern or corporate body. It means that the company will no longer operate in its normal capacity as it used to be. Now, what is the relevance of the just and equitable principle? Just and equitable principle, it is fair to do so. Now, the case in question is Ibrahimi v. West Bonny Garage Limited, and this is what the court stated. Just and equitable enable the court to subject the exercise of legal right to equitable consideration that is of a personal character arising between one individual and another, which may make it unjust or inequitable to insist on legal rights or to exercise them in a particular way. It will be impossible and wholly undesirable to define the circumstances in which these considerations may arise. So the just and equitable principle enable the court to look at the balance between people who have the legal rights in a company as against the individual right, as against the group as well, before any winding up order will be made. So the law will strike a balance concerning the individual personal rights. So there will be, the court has to strike the balance between the misunderstanding in terms of one enforcing his or her right against the other. So where it will be unjust or it will be inequitable or it will not be fair to insist on someone's legal right or exercise them in a particular way. So the just and equitable, we are trying to, the court was trying to explain that if you consider the personal character arising between one individual and another, and which it will make it unjust or inequitable or fair to insist on someone's legal rights or to exercise them in a particular way, then the court will not insist on the winding up. So is it equitable? Is it just for the company to wind up the company or not? And the court is saying that they cannot foresee all the circumstances, or they cannot list all the circumstances that should be taken into consideration. It means that each case will be decided based on its own facts. Let's now look at the animosity between company and members. When animosity exists among all of a company's directors and members, then regardless of the profitability of the business venture, it may be just and equitable to wind up the company. And this is supported by Unity Tobacco Company Limited. What this means is that if the directors are not in good terms, if the directors and the members in the company are not in good terms, in fact, unnecessary disagreements, then even though the company is making profit, it is fair, just, and equitable to wind up the company, because you cannot run a company when there is no unity. Also, when the company's main object is gone or never exists, it shall be just and equitable. So the main object of the company is no more, then it will be just and equitable. It will be just and equitable to wind up the company. And this is also supported by INRI German Date Coffee Company Limited. So this case is giving a proposition that, in fact, look, when the main object is no more existing, it is better you wind up the company, or you call for the company to bring to an end. The next point is that when the company has been carrying on business at a loss and it is insolvent, it is just and equitable to do so. This one is obvious. If you are carrying on business and you don't make profit, then you keep on incurring losses every year. Then the best solution for you is to wind up. The case of Billy Vicao and another give the following expression or provision. In law, it may be just and equitable to wind up a company where it is carrying on business at a loss and its remaining assets are insufficient to pay its debt. But the mere fact that the company is being run at a loss is insufficient. It must be shown that there is enough reasonable hope of the ultimate profit. Once a company is wound up and dissolved, it is dead and buried. So this is what the Justice Benny is saying. Say, look, if the company is carrying on business and the company is carrying on losses, then it is better the company is wind up, and the remaining amount is not sufficient to pay its debt, then obviously it is good to wind up the company. However, the mere fact that the company is running at a loss is not sufficient to dissolve the company. There should be a reasonable ground that there is no hope that the profit will go up, or there's no hope that they will get profit one day. With that one, it is better to wind up the company. We are saying that winding up and the fact that the company has been wind up and it has been dissolved means that the company is dead and it is no more. Once it is dead and buried, it is no more. Remember, once the dissolution takes place, anybody at all can form a company and take the same name, since the name would have been struck off from the register of members and has been published in the company's bulletin the same. By way of summary, in our study of this session, it has come out clear that the court, in considering the application in relation to operation, may make a winding up order. We also noted that when animosity exists between or among a company director and members, it may be just and equitable for a company to wind up. Thank you for making this class possible. Enjoy the rest of your day. Goodbye.